I'll say that this is a notice of motion application dated 26th of June 2024, filed under certificate of urgency by the petitioner applicant who sought several orders which are outlined on the face of the application. So I'll go now to analysis and determination. Arising from the submission and petitioner's pleadings, it is my considered view that the following issues arise for determination. 1. Whether prima facie a Gazette notice number 7861 of the 25th of June 2024 was issued in compliance with the Constitution and the law or legislation. Number 2, whether the court should issue or grant the order sought in this application. The first issue is whether prima facie the Gazette notice number 7861 was issued in compliance with the Constitution and legislation. To answer this particular question, it is necessary to set out the terms of the impugned Gazette notice, which also includes the provisions of law that were relied on. The Gazette notice in question was annexed to the petitioner's affidavit. It reads as follows, and I quote, Gazette notice number 7861, pursuant to Article 241, sub-Article 3B of the Constitution of Kenya, as read with sections 31, subsection 1A, 31, subsection C, 33, subsection 4, and 34, subsection 2 of Kenya Defence Forces Act, Cap 199. The Kenya Defence Forces is deployed on the 25th June 2024 in support of National Police Service in response to security emergency caused by ongoing violent protests in various parts of the Republic of Kenya, resulting in destruction and a breaching of critical infrastructure. Dated 25th June 2024, and then Barred Wari, Cabinet Secretary for Defense and Chairperson of the Defense Council, end of quote. The provisions of the Constitution and the statute under which the said notice was premised reads as follows. I will start with the Constitution, Article 241, sub-Article 3B. The Defense Forces shall assist and cooperate with other authorities in situations of emergency or disaster and report to the National Assembly whenever deployed in such circumstances, end of quote. The other provisions are in the statute, that is the Kenya Defence Forces Act, and they fall under Part 3 of the Act, that is the Kenya Defence Forces Act, which is ended cooperation with other authorities in Kenya. I don't think it is necessary, but I think I can just read. Let me just read them very fast. Section 31 reads cooperation with other authorities. Subsection 1 says the Defense Forces, paragraph A says, shall assist and cooperate with other authorities in situations of emergency or disaster and report to the National Assembly whenever deployed in such circumstances. Subsection C, which was also relied on by the Cabinet Secretary, reads, shall in the interest of national security cooperate and work with other security organs in the discharge of its constitutional mandate. Subsection 2 requires that the defense forces, when the defense forces are deployed for any purpose, as contemplated in subsection 1A and B, the Cabinet Secretary to inform the National Assembly promptly and in appropriate details, giving reasons for such a deployment, place where the defense forces is being deployed, period when the defense forces is being deployed, expenditure incurred or expected to be incurred. Subsection 3 provides that if the National Assembly is not in session during the first 7 days after deployment of the defense forces contemplated in Article and Subsection 1, the Cabinet Secretary shall provide the information required to Speaker of the National Assembly. The other section is Section 33, which is deployment in support of National Police Service. The defense forces may be deployed in joint operation and in support of National Police Service and any other authorities in situations of emergency or disaster. Subsection 3 says, whenever the defense forces are deployed pursuant to subsection 1, the Inspector General of Police Service shall be responsible for the control and overall superintendence of the operation. We now turn to Regulation 34 of support regulation, and I think that is not necessary for now. Then we go now to my understanding of those provisions. From my reading of the above provisions, it is clear there are two possible ways or situations that may necessitate the deployment of the military to support the National Police Service. The first situation is what is provided for under Article 241B of the Constitution, which deals with emergency situations or disasters. The second situation is what is provided for under Article 241C, which covers unrest and instability. In the two scenarios, there are prescribed procedures to be followed. The first scenario, which deals with situations of emergency or disaster, the military can be deployed to be followed by a report that is to be given to Parliament. In the second scenario, which pertains unrest and instability on any part of Kenya, there must be prior approval of Parliament before the deployment. What then is the meaning of emergency situations or disaster, which is referred to in Article 241B that the Cabinet Secretary applied? The Constitution is silent on the meaning. Two different interpretations were advanced by the rival submissions of the parties in this petition. The petitioner was of the view that the state of emergency ought to have been declared in the manner provided for in the Constitution, specifically Article 58, for Article 241B to kick in on account of emergency, while the respondent urged the court to take the Black's Law Dictionary meaning of the word. It is my considered view that the word as used in Article 241B is actually not a technical terminology and is used in the ordinary sense, for if it were used in the technical sense, or it were meant to be used as a special word, then the conjunctive or after the word emergency, which relates it to the word disaster, would not have been inserted there. The fact that the framers of the Constitution used a different word to describe the situations that may call for such deployment shows that they did not intend to give the ones any special meaning as is used elsewhere in the Constitution, where certain specific procedures associated with them applies. It certainly does not mean or have the meaning of a state of emergency as used. It is used in the sense as used in the Constitution. That one should take the ordinary English meaning which under the Oxford English Dictionary 11th edition means serious, unexpected, and potentially dangerous situation requiring immediate action. Listening to the respondents, especially the second, third, and fourth respondent, they argued and the court to take judicial notice that indeed what necessitated the quick action of deployment of the military was when Parliament building, a critical national government institution, as well as a symbol of democratic governance, and the office of the Chief Justice were vandalized after the demonstrators overpowered the police and descended on the key government institutions. Such an occurrence, coming from supposedly peaceful demonstrators, would fit within the definition of serious, unexpected, and potentially dangerous situation requiring immediate action. For who would have anticipated that a peaceful protest would take such a turn and result in a serious breach of security of that magnitude? This court today is faced with two competing constitutional values: the need to protect the life and property, preserve peace and honor and public safety, and the need to uphold and protect the open public expression by citizenry in a democratic state. The court must uphold the right of the individual citizens to assemble, demonstrate, and picket under Article 37 of the Constitution, but it must also be conscious of the fact that if expressed in a dangerous manner that endangers peace, honor, and public safety, that can cause substantial harm that cannot certainly be within the prescribed boundaries of expression. The government must also act in the manner prescribed by the legal procedures in intervening in such situations. The petitioner has argued that the intervention of the military to support the police would cause fear and intimidation to Kenyans and prevent them from expressing their rights and prevent them from expressing themselves. Although Kenya Defence Forces Act at Article 34(1) provides that such deployment shall comply with the constitutional standards relating to human rights and fundamental freedoms, this court does not consider the petitioner's fear to be an idle contention. It is common knowledge that military, by its nature of training, is not trained to deal with civilians, but armed combat, where the military principle is generally the use of force to resolve crises. I would therefore agree with the petitioner that deploying the military in a blanket manner without defining the scope or nature of the intervention, the duration of such intervention, is a dangerous trend that can bring about militarization of the country, which is antithetical to the enjoyment of rights and freedoms. This would muzzle civilian population. This would